also joining virtually. So we thank you and we welcome you to this panel discussion. Our topic this afternoon is the influence of public international law on investment arbitration. And this is, in my view, a great topic because I think we often take for granted the role of public international law in investment arbitration, despite how central it is to the proper resolution of investment disputes. So we know in most investment treaty arbitration, the tribunal is mandated to resolve the dispute before it, largely on the basis of international law. So accordingly, it should apply the law of treaties to determine the scope and application of the relevant investment protections and defenses. Sometimes this exercise involves assessing the existence of an application of customary international law, such as where the minimum standard of treatment is relied on or the necessity defense is invoked. If the respondent is found to have breached its obligations under international law, then the tribunal turns to the international law of state responsibility to determine whether and to what extent reparations are owed. So this is the role of international law that we've come to expect in investment arbitration. But arguably, there's a lot more to think about. We sometimes don't spend enough time considering, for example, what international law sources investment tribunals are relying on and how they go about selecting those sources, how tribunals are interpreting and applying these sources, and whether they're doing it properly, and whether tribunals are adequately addressing the sometimes complicated interplay between public international law and investment treaty law. So fortunately, that is the task of our panelists today, as they will explore the influence of public international law on investment arbitration in many important areas. So just a point on process before we begin. Our panel discussion will proceed as follows. Each panelist will present on the influence of a particular area of public international law in investment arbitration. These areas will include public international law sources, treaties, state responsibility, substantive investment treaty obligations, and damages. Then following each presentation, there will be an opportunity for the remaining co-panelists to provide comments and reactions. After the last round of discussion, we hope to have about 10 to 15 minutes for questions and answers. Please note that this year there will be no virtual breakout rooms. So apologies to those on Zoom, but we will have no breakouts. And also, very unfortunately, we learned just a couple hours ago that Professor Dupuy cannot join the panel discussion virtually, but we have adjusted accordingly, and we hope to express his voice in other ways in the panel discussion. So let me now turn to introducing our very esteemed group of panelists, and I'll introduce them in the order they will be speaking today. I'll start with Professor Dr. Jana Karakatsanis. He will start off our discussion on the topic of public international law sources. Professor Radi is Professor of Public International Law at the University of Louvain and at Sciences Po Law School in Paris. He is also an invited professor at the Hague Academy of International Law. His areas of expertise and interest include state responsibility, the law of treaties, international arbitration, international investment law, energy law, and space law. He's the author of several publications in the field, in these fields, including recently Rules and Practices of International Investment Law and Arbitration. He's a member of the ICSID panel of arbitrators, and among many other prominent positions, he is on the list of trade and sustainable development experts for dispute settlement panels under trade agreements concluded by the EU. Kiran Gore will next address the interpretation of treaties in investment arbitration. She is an arbitrator, dispute resolution consultant, and counsel with many years of experience advising governments, corporations, institutions, and individuals on public and private international law, international development, foreign investment strategies, international dispute resolution, and legal investigation and compliance efforts. Kiran advocates before U.S. courts, ad hoc arbitration panels, commercial and investment tribunals, and investigative authorities. After working for various law firms, she now has her own independent law practice, and she's also an academic. As a professorial lecturer in law at GW, Kiran focuses on public international law, international dispute resolution, constitutional law, civil procedure, and written oral advocacy. She's also just put out a new book which she co-edited, entitled The Vienna Convention on the Law of Treaties in Investor-State Disputes, History, Evolution, and Future. Next, we'll then cover Professor Dupuy's topic as best we can. Then Jose Antonio will discuss substantive investment treaty obligations. We know him well. He is founding partner of X Strategy in Washington, D.C. and in Bogota, and chair of the arbitration and international law practice at his firm. He works as international counsel in investment and commercial disputes under all the major international arbitration rules. He serves as an arbitrator and provides advice on public international law and investment law to sovereign clients, state companies, and investors. As we all know, he is the co-founder of Washington Arbitration Week and the World Arbitration Update. Jose Antonio was a former lead negotiator of investment treaties for Colombia and former ICSID legal counsel. He also teaches a course on investment arbitration at Georgetown, where he obtained his doctorate. And last but not least, Josh Simmons will be presenting on damages in arbitration, investment arbitration. Josh is of counsel at Wiley in DC. He has extensive experience in treaty and commercial arbitration proceedings around the world. He has represented foreign sovereigns and international investors across a broad range of industries. Josh also advises companies on national security law, public international law, and transnational litigation in US courts. He teaches international arbitration as an adjunct professor at the University of Virginia School of Law. And prior to joining Wiley, Josh served as senior advisor in the Office of the Legal Advisor at the US State Department. So with those introductions, we'll turn first to Jana, who's going to present on international law sources. Take it away.
Thank you very much, and thank you very much, Jose Antonio, for organizing this wonderful week and having me here today. So, good afternoon, good morning, good evening, wherever you are. So I've been asked to talk about customary international law, CIL, and general principles of law. So I will not enter into their content. I will look at it from the perspective of the sources of international law. So we have about 10 minutes, so I will be pretty straightforward, addressing mainly three issues. Why does it matter to have a look at CIL and general principles of law? And then I will focus excessively on CIL and those general principles. So why does it matter first? Well, despite the fact that we have a great number of international investment agreements currently into force, it remains that a number of investor-state relationships are not covered by an international investment agreement, which makes, in particular, customary international law relevant and useful. Second reason, even when we have such an international investment agreement, we all know that IA provisions are not self-sufficient. There is often a need to rely either through interpretation in relation to Article 31.3c of the VCLT, or either as a matter of applicable law, either when international law is part of the applicable law, or when in the IA provision there is a reference to CIL or to general principles of law, which is pretty rare, of course. Here, we can rely on CIL and those general principles of law to substantiate the content of those IA provisions. So two main reasons why CIL and general principles of law are important. So CIL first. Here I will address three issues, two main ones: the interplay between CIL and international investment agreements. Second, the interplay between CIL and arbitral practice. And subsidiarily, I will touch upon burden of proof. So CIL and international investment agreement. So there is a consensus in arbitral practice that IAs participate to the formation of customary international with two different approaches in arbitral practice. Some tribunals have suggested or argued that international investment agreements in and of themselves can make customary international law. Others have suggested that IAs can contribute to the CIL process. So the first approach from a public international perspective is very controversial. I will not delve into this one now, we can do it later. I will focus on the second approach, the contribution of IAs to the CIL process. So if you look at the case law of the International Court of Justice, the Diallo case recently, previously the Continental Shelf case, or more famously the North Sea Continental Shelf case, this is something which is possible, but there are conditions to be met. Those conditions were set out by the court in the North Sea Continental Shelf case. Here of importance, the court in that case was discussing a multilateral treaty. So when applying those conditions to our field, we really have to be cautious and apply them by analogy. So what are those conditions? So I will discuss those conditions shortly. I will not enter into the details of each IA provisions, obviously. Then the reasoning has to be adopted depending on which provisions we are looking at precisely. So first condition, the provision shall have a norm-creative character. So this first condition, the issue in our field is the normative vagueness of IA provisions. And the question arises whether this normative vagueness bars us from considering that it has a norm-creative character. Second condition set out by the court, there shall be a widespread and representative participation to the convention, including that of those states who are especially affected. So again, by analogy, we can say that we have a widespread and representative participation to treaty practice in our field, including that of those specially affected states. But here the issue is that of the similarity. Do we have enough similarity between IA provisions to argue that this second condition is met? Third condition, outside the context of the convention, there should be an extensive and virtually uniform state practice. So here this requires to look at states' declaration and also importantly to look into domestic legal systems, which in terms of evidence is quite a challenge, an issue I will get back to later. Fourth and last condition, last but not least, opinio juris, the acceptance of the practice as a law. From a positivist, a voluntarist point of view, this is a challenge in our field. Why? Because obviously the practice which results from the treaty is not tantamount to opinio juris. Then can we consider that when a state enters into an international investment agreement, it does it out of a sense of legal obligation? This is also an issue which can be discussed. So to sum up, in our field, IAs can be seen as contributing to customary international law, but the analysis should be much more thorough than what it has been in the past in arbitral practice. Second point, interplay between CIL and arbitral practice. So we have witnessed in the past years that states in the treaties, they make it very clear that customary international law is based on state practice and opinio juris. Why do they do so? Well, they do so because, as you know, arbitral tribunals have a strong, very strong tendency to refer not to state practice, but to arbitral practice when they discuss customary international law. So from a public international law point of view, the issue is not so much that they rely on past arbitral awards. The issue is that they rely on past arbitral awards which themselves do not discuss state practice and opinio juris most of the times. So we end up in a situation where there is kind of a self-referential practice among arbitral tribunals. Arbitral practice coming, replacing state practice, and more fundamentally, customary international law being replaced by jurisprudence constante, which is, again, from a public international law point of view and a theory of sources, quite an issue. Well, we all know why arbitral tribunals proceed like this, because evidencing customary international law is a challenge. So, which leads me to my subsidiary point, burden of proof. So here, different views among arbitration tribunals. So first approach, it's up to the claimant to evidence customary international law, Glamis Gold, for instance. Another approach adopted typically by the tribunal in Windstream, they made a distinction between existence and content. So evidencing existence of CIL, it's up to the claimant. But evidencing the content, this is to both parties to evidence their views on the content of customary international law. Interestingly, here, the Washington Tribunal also say that the tribunal has a role to play in this respect, adopting a reasoning akin to the Urano-Vidkoria principle. Now, let's move to general principles of law. So here I will talk only about general principles of law recognized by civilized nations, adopting the very anachronistic formulation of Article 38 of the ICJ statute. So it's an invitation to look into domestic legal systems. And actually, arbitral tribunals have been quite criticized for the way they review the content of domestic legal systems for two main reasons. First of all, the lack of methodology in what's the content of domestic law. How do you appraise the representativeness? How do you appraise the similarity between the domestic laws? Issues which are necessary in relation to general principles of law recognized by civilized nations. The second main criticism is the subjectivity and the selectivity of arbitral tribunals when picking up domestic legal systems. I think that to make sense of this criticism and more generally to make sense of arbitral practice, it is necessary to make a threefold distinction. So first of all, it is necessary to make a distinction between those situations, those cases where tribunals rely on general principles of law recognized by civilized nations per se as such, and those situations where they directly rely on domestic legal systems, on domestic law, without arguing that there is a general principle of law recognized by civilized nations. The second important distinction is the role. Is it a gap-filling role? Is it the interpretation of vague provisions? Or is it about confirming an interpretation which has been reached on another basis? And the third distinction is, are we talking about legality, strictly speaking, or are we talking about legitimacy? So we can play out with these distinctions, but for instance, if we take this gap-filling role and the reliance on general principle of law recognized by civilized nations, from a legal point of view, not analyzing the content, not discussing the similarity, this is an issue. This is a legal issue. But this legal issue is not as big when domestic law is used as a confirmation to an interpretation which has already been reached. On the other hand, from a legitimacy perspective, for instance, the subjectivity, the selectivity is also a problem when you rely on domestic law to confirm an interpretation which has already been reached. And here, this comes as a limit. It has a negative impact on the argumentative value of relying on domestic laws. And more fundamentally, this limits the argumentative value of the public law analogy, so which is a different issue that we can discuss later. I will stop here for the time being, and I thank you all for your attention.
Thank you very much. Thank you for sharing those insights. We'll turn now to some comments and reaction from co-panelists. Maybe we'll start with Huron.
Sure. But I wanted to pick up on the idea of identifying and codifying public international law. And this is something that the ILC, the International Law Commission, has been doing for about 75 years now. They just celebrated their 75th anniversary of their statute last week, actually. And one aspect where this has happened in particular with relation to the law of treaties is the Vienna Convention on the Law of Treaties, which was entered into force about 50 some odd years ago, 52 years ago. So, excuse me, open for signature 52 years ago and entered into force about 40 years ago. And I'll pick up on that more in my main remarks later. But the codification process has also brought into relief the issue about customary international law and how much of this codification reflects customary international law. The US, importantly, is not a signatory to the Vienna Convention on the Law of Treaties, yet the US, in many of its arbitral submissions, and also on the State Department's website. So maybe Josh has views on this. There's a Q&A section on the State Department's website that says, does the Vienna Convention on the Law of Treaties apply, or does the US, believe in the Vienna Convention on the Law of Treaties? And the response is no, but we understand it to be reflective of customary international law more broadly. And amazingly, that Q&A on the State Department's website is what is cited by participants in investor-state disputes. So if we talk about sources of public international law, we've devolved, at least from my perspective, into a he said, she said of Q&A on the State Department's website in the United States. And when I was working on the book on the VSCLT, I wanted to find something more authoritative, and all I could find was references to this Q&A on the State Department's website, which on top of that is a archived page. It's not even a current web page. It's like from 10 years ago, and it comes up in the Wayback Machine as an archive, which is what participants in these disputes cite to. There are letters that can be referred to from the 1970s, including State Department submissions and international disputes that also refer to the binding nature of the VCLT as a reflection of parts of it, as a reflection of customary international law. But I throw that out there as food for thought, because if we think about the sources of law, it becomes very convoluted, because as Professor Yannick has referred to, there's first, there needs to be consensus. It needs to be a reflection of practice, and then consensus as to its binding nature. And how do we derive or understand that in a very evolving universe where consensus is changing, state practice is changing, and most interestingly, the sources can sometimes be quite self-referential, including amongst arbitral decision-making and also party submissions. Oftentimes, you'll also find party submissions, in particular state party submissions, as becoming a source of reference for future litigants. So throw that out there as food for thought for now. Josh, you can tell us all about this website on the State Department.
I don't think there's an international law limitation on the format of state views. So,
Thank you. Jose Antonio, anything to add?
I recently had to investigate the same issue. How, to what extent U.S. courts have embraced the Vienna Convention as customary international law, and I believe there might be some limited case law in which they have cited statements by the State Department. I didn't find the Q&As, but
I'll show it to you.
No. But I'm sure that you're right. But
Can you share your screen?
to my chagrin, I didn't find the Q&As. But I believe that there are some U.S. Court of Appeals of the D.C. Circuit cases that may have referred at some stage to statements by the State Department. To what extent?
Can I show my screen? Is that allowed?
Sure.
Yeah.
But in any event, I mean, the reactions that I have concerning the customary international law and as a source of investment treaty arbitration, and as a source of or used or referred to in cases, I believe that Yannick put it very well. When I was first, perhaps my second year at ICSID, there came the decision of CMS versus Argentina, which you might have read or can refer to. It was after the I believe that after one or two cases, it was actually the first case of the pacification crisis. So it was a much expected award. And if you look into the weeds of that award, there's a reference to national treatment being customary. And to those of you, us, that may have an innate sort of DNA on public international law and that believe in general practice and opinio juris, that is kind of a sacrilege. Simply putting it out there without any analysis or without any strict study in terms of where's the practice, where's the opinion juris, simply because you have 3,300 plus treaties, investment treaties that all have a common title called national treatment, doesn't mean that the elements are there. So at least in this respect, I would say the analysis needs to be very careful. And I really liked the distinction between arbitral practice and state practice, which is precisely what shouldn't be embraced as customary, because customary takes a very rigorous process to prove that it is there. That's my few comments.
Thank you. We're going to shift gears a little bit and go back to Huron to talk about the influence of treaty law in investment arbitration.
Thank you. So let me start by saying a lot of the remarks I have on this topic are reflected in my book, which just came out in September, that Lee kindly mentioned in his introduction. The Vienna Convention on the Law of Treaties finds its source in the very early days of the International Law Commission of the UN. When the ILC was first formed in 1948, one of the first things that they did was come up with a list of the most important topics of international law that are worthy of codification. They came up with 10 such topics. 3 of them were selected for immediate work, and 1 of them was study and codification of the law of treaties. That process began, if you put it into time context, it began shortly after the UN's formation. It began in a time, very different era, post-World War II era, when a lot of the nation states we know of today did not yet exist, and therefore not participants in a lot of these processes. I think reflecting on those sources, not only for purposes of treaty law, but also customary international law and other sources of public international law is really illuminating, because it means that there are many participants and players in international law and practice today that simply did not literally have a seat at the table when a lot of the institutions that today, such as the UN, that we are quite critical of and quite beholden to, drive a lot of the practice and both in international relations, international law, et cetera. So I throw that out there for consideration as a background piece, because history does matter. As for the law of treaties, the codification and the work at the ILC took nearly 20 years. It was about 17 or 18 years of back and forth. There were special rapporteurs assigned to this topic by the ILC. There were 4 of them, successive rapporteurs. And each one had, interestingly enough, a different approach. Some thought that codification would involve preparing draft articles for consideration and use by others. Very few of those rapporteurs thought that a treaty on the law of treaties was the appropriate way to conduct that codification. And then there was some back and forth, right? Because what we ended up with was the VCLT, which is in fact the Treaty on the Law of Treaties. So in 1969, when the VCLT opened for signature, what's interesting is while its actual substantive provisions, and I'll talk about the substantive provisions, were not considered fairly controversial, many UN member states signed without objection on its terms. It did take about 11 years for it to enter into force, so to get the consensus of signature that was required. But also, it happened a bit slowly, but without much resistance. So what does that tell us about the reflection of the principles in the VCLT, and how does that reflect upon it as a source of international law? Well, a few things. First being that it means that the work of the ILC was productive, because their mandate was to codify existing practice on the law of treaties, and not to develop newer controversial principles on that. So what does the VCLT contain? There are rules on the entry into force of treaties, the exit from treaties. This is incredibly important today. As Jose Antonio mentioned, we have 3,300 EITs and growing, investment agreements and growing, I think, daily. It also means that the rules on interpretation, which are employed quite extensively, those are at Articles 31 through 33, are incredibly instrumental as we think about arbitral practice and other practice about interpretation of treaties. And there are various other source rules, including on territorial application of treaties, for example, which are becoming increasingly more important in our fragmented world. So I come back to where I started with my remarks and remind you that we're in a very different world today than when we were when the VCLT was being developed and then signed and entered into force. If you look at arbitral practice in particular, in our book, we detail the more than 350 decisions and orders of investor state tribunals. My co-editor, Esme Sherlow, conducted that research. And the more than 350 some odd decisions and orders reflect that, well, number one, the VCLT rules are used a lot. Some of them are used a lot more than others, including the ones on interpretation of treaties. So in particular, Articles 31, 32, and 33. And there's something to be harnessed in that. I look at this from a very forward-looking perspective. And if we have so much arbitral practice to draw from, and we have an increasing trend towards transparency in investment agreements and also in investment disputes and how those proceedings and submissions are conducted, it means there's more information to harness for future purposes. So if we could come back to the lens of public international law more broadly, it means that ISDS practice is of interest to all participants in public international law and not just those who are interested in international investment law, because we have so many examples of putting these rules and articles into practice, more so in other fields. The other angle, and this is my last point that I might make for the moment, is we do have a very crowded space, right? We have 3,300 international investment agreements. We have an increasing number of states that are participating in the international law arena. Each of the various fields of public international law, so we look at everything from climate law to space law to investment law, has more and more instruments at play. So how do we reconcile amongst all those various instruments? And what do we do when human rights law and investment law start to interplay together because issues that are relevant to both are at issue, in particular in an investor state dispute? And even there, this is my thesis and why I'm in love with the VCLT. The VCLT offers solutions, right? So the VCLT's interpretive guidance at Article 31, and the ILC referred to this in a recent report, a 2006 report on fragmentation in international law and how to resolve it, is that, well, none of these instruments are ever rendered irrelevant. It's just that which one of the instruments that you are looking at has greater importance to the context and purpose that is sought to be achieved. So if we look at regime interaction in this increasingly crowded space, investor state tribunals and other decision makers can conduct an analysis where they look at the various instruments and treaties that they have as sources of law and guidance, pick and choose the parts that are most important to the particular context that's at issue. And meanwhile, the other instruments stay, but perhaps fall into the background, but never become irrelevant. So if we look at how to deal with this increasingly crowded space, I think there's more innovation that is needed, but the VCLT remains quite instructive for future practice. So I'm quite optimistic. I think the VCLT offers a very constant source of rules and guidance. At the same time, I think there's room for innovation, and something that you are seeing happening in the law of treaties now is that states are being much more directive. So while the VCLT offers default guidance on how to enter into force, how to exit from treaties, so how to interpret treaties, so on and so forth, what we are seeing in investment agreements is specialized guidance on what should happen. So NAFTA and USMCA is a great example, right? The USMCA provides for how the sunset of NAFTA would be conducted. And if you've still got claims to make, you've got 6 more months to make them at the moment because there was a 3-year sunset period. At the same time, the treaties are also now starting to specialize interpretive guidance on, well, what are the sources of interpretation? And what I've been really impressed by is sometimes, and there's one example, it's the Kazakhstan-Hungary BIT that was entered into in 2020, specifically says that this treaty is to be interpreted using the rules of the VCLT. So that kind of very directive guidance is useful for participants in these kinds of disputes. So I'll stop there for now. Obviously, I've got a whole book of material I can talk you through. Thank you, Lee.
Thanks, Kieran. No, thanks to everyone. Get the book. It's great. We'll open it up now for comments and reactions. Yannick, you have anything to say?
Yeah, I mean,
Great.
many things, Karen, very insightful. A few words on interpretation and the guidance. But I mean, Article 31 is to be considered as a general rule. So that's a whole to be applied as a whole, knowing that there is no hierarchy between exegetical, theological, contextual interpretation. But then when you look at arbitral practice, it is not always the case that Article 31 is used as a whole, as a general rule. Sometimes the focus is more on either methods of interpretation. The impression being that there is kind of a hierarchy sometimes, which is established between what should not be characterized as a hierarchical exercise. Fragmentation, wow. So for next year, we can have a panel on fragmentation. So here again, guidance, yes, shall be taken into account together with the context and irrelevant rule of international law, which is applicable in the relation between the parties. So that's very useful. It's the master key of the House of International Law, to use the term of the former Chinese ILC member. It's a bridge between international regime. The problem is that in terms of guidance, this is it. Because what does it mean to take into account? And the problem is that any arbitrator, any tribunal will likely have a different approach, or at least there will be groups of arbitrators and group of tribunals, which will have a different idea of what it means to take into account environmental law, what it means to take into account human rights law, what it means to take into account labor law. So this is very useful, as you said, it provides guidance, but there are also a limit. There is kind of for a need to rationalize the way the interpretation is conducted to be more in line with public international law standards and to be more in line with this idea of systemic integration, which is very important for public international lawyers. Thanks again.
Thank you. Any other comments from the panel? No?
I very quickly, the discussion about the four criteria to be applied under Article 31 of the Vienna Convention on the Law of Treaties, when thought in investor-state arbitration practice, and how you should balance and how you balance that, it always makes me think about the living of Prosper Vale in one of the investment arbitration cases. I mean, he took an approach of which was more purpose-based, whereas his two arbitrators, appointed arbitrators by the parties, took a very exegetic or textual approach, and that to me, that decision sums it all in terms of well, it seems to me, and I'm not indicating that it's right or wrong, but it seems to me that there is a general consensus that although technically they should not be hierarchical, it seems to me that the first approach is the textual approach. And I'm very respectful of that approach. But Prosper Vale, public international law professor, he took into account the reading of the preamble and consider, well, I should go more for purpose. And the disagreement was so fundamental that he ended up leaving the tribunal. And that interpretation, which really related to whether or not you could be legitimately a juridical person suing under the ICSID system, despite being owned by a national of the same host state, is one that seems now to be mostly accepted. So that.
If I could respond for a moment on this hierarchical versus what some call the crucible approach, which is everything all at once, I think it's a flaw of arbitral practice and advocacy more so than the decision makers, because if you look at the way we conduct investor-state dispute resolution, typically the parties have a shot or two shots to make all their arguments that they intend to make, including those on how interpretation is to be approached. So if they have various arguments, regardless of whether they intend to resort to them hierarchically, they need to make all of them at once. And then the other side needs to respond to all of them at once. And then there might be a second round of the same thing. So what that leaves the tribunal, the decision makers, with is needing to, wade through that morass of various approaches all at once, even if a more hierarchical approach or dogmatic approach or, some kind of systematic approach could be the more coherent way to deal with it. I think it's a reflection of what we as counsel sometimes do, that we make a bit of a mess of it sometimes, which makes it more difficult for the interpreter and the one who needs to decide how the application is to be taken into account.
If I could just add one thing on that, and this is picking up on Janek's differentiation between state practice and arbitral practice. The approach to the Vienna Convention on the Law of Treaties is different as a public international lawyer, for example, representing a government, as opposed to a party in the case. So it is true that the tribunals are going to be limited in some instances to the advocacy that's presented to them and might not approach it as holistically as a public international lawyer would.
Thank you. Good points, everyone. We're going to move now to the topic of state responsibility, which Professor Dupuy was going to address. We're going to do our best now to try to replicate what he might have said. Probably not as well as he could, but the best way we thought to start was to literally read his words from a recent article he's put out. It was in the ICSID Review, volume 37. It was the special issue in the 20th anniversary of our CWO, or the draft articles, state responsibility. He provided the concluding remarks, which were then memorialized in a paper that is entitled "A Reference Text Partially Victim of Its Own Success," he asks. And so I'll just read just a couple of short excerpts, hopefully the right ones, to give you a gist of what his point is, and then I think other panelists may react. So he starts by noting that the draft codification of the law of responsibility is aimed at relations between two or more states, each with equal sovereignty, intended to be applied solely within the framework of public international law. It is not in itself conceived to serve in the context of a dispute between two parties, only one of which is a sovereign state and the other a legal person primarily subject to the internal law of another state. Then he goes on to say, he actually quotes James Crawford, who notes, and I'm quoting Crawford, there is a fundamental and often misunderstood difference between the three substantive parts of the text of the draft articles. Crawford says in particular, part 1 is different in scope from parts 2 and 3, and this difference is extremely relevant to investment treaty arbitration. Then Professor Dupuy picks it up and says, indeed, this point remains absolutely central. A number of tribunals still seem to have difficulties drawing all the consequences from this difference. Then Professor Dupuy goes on later to talk a bit about the difference more. He says the second part of the draft articles defines the consequences for a state having violated one of its obligations, but in relation to one or more other states, not in relation to a foreign private person who is a national of another state. It is particularly concerned with the conditions of reparation for the damage caused by this violation. Then finally, his main setup point here in his article is that both sets of articles, meaning parts 2 and 3 of the draft articles, cannot be used but by analogy, because he says they don't apply directly to individuals, but only to states. And with that set up, I'll try to turn it over to Josh, who I know has some views on how this perhaps distortion by tribunals plays out in the damages realm.
So I might start by disagreeing that it's a distortion.
Okay.
I do agree that the principle of separation between parts 1 and parts 2 are important, and it's good to clarify that part 2 of the draft articles of state responsibility apply to state relations per se, as opposed to investor-state relationships. But one point that, why is it that Professor Dupuy, and if he was here, I would ask him this too, but why is it that it still applies by analogy? What does that mean? I think the answer probably comes from Article 33 of the draft articles of state responsibility. So Article 33(2) states this part, again, part 1, part 2, is without prejudice to any right arising from the international responsibility of a state which may accrue directly to any person or entity other than a state. So this is a carve-out, effectively, that recognizes that there might be an application that's not state to state. And the commentary goes on to explain that when an obligation of reparation exists towards a state, reparation does not necessarily accrue to that state's benefit. In other words, it could accrue to someone else's benefit, even in a state-to-state relationship. Think of a bilateral investment treaty where there's a benefit that accrues to an investor. The example given here is human rights. So a state's responsibility for the breach of an obligation under a treaty concerning the protection of human rights may exist towards all other parties to the treaty. In other words, all other state parties to the treaty. But the individuals concerned should be regarded as the ultimate beneficiaries, and in that sense, as the holders of the relevant rights. Individual rights under international law may also arise outside the framework of human rights. One of the examples then given in the next comment is that in the case of rights under bilateral or regional investment protection agreements. So I think, why is it that the principles in the Articles of State Responsibility can apply by analogy? It's that they do not apply directly per se, because it's a state-to-state principle, but they do apply by analogy, and I think Article 33 of the draft articles states that expressly. So I don't think it's a distortion when investment arbitration tribunals call upon the principles set forth in the Articles of State Responsibility. Perhaps they could explain more precisely that this is not an exact application of customary international law as reflected in the draft Articles of State Responsibility, but the by analogy application is still correct.
Great, thank you, Josh. Any thoughts on that?
If I could just maybe zoom out from those remarks a little bit and put them into context. So we have primary sources of international law, and then we have secondary sources. And I think that the draft articles are intended to be secondary sources. But what's interesting is that the draft articles themselves and their commentary have been extensively relied upon by investor state tribunals. And then there is that self-referential propagation of, citing to prior, and there's no precedent system, but we cite to prior decisions and prior interpretations and applications of the draft articles. So it's developing sort of like a shadow system of rules. It's like the metaverse. It's like there and not there, and it shouldn't be there. And Jose Antonio didn't like that comparison at all. but there's something to be said for how these are not primary sources, but not only do the draft articles themselves, but their commentary are cited so extensively by litigants in investor state disputes, and as well as the decision makers, that there's something to be said for what this arbitral practice means for the field of investment law, but also for public international law more broadly, because similar to the remarks I was making about the VCLT, well, what happens in the investor state context has implications more broadly, because it's a lot of practice and we can learn and grow from that practice. Same with the draft articles, I think.
And I have very few reaction on that, if I may. The subject, today's subject, or this panel's subject is the influence of public international law in investment treaty arbitration. And when you see the subject, I mean, you can sort of take each one of the sub-subjects and ask the question, what has been the influence? So you took the sources, custom, treaties, and now we'll go into state responsibility. Then we'll go into substantive provisions. And at the end, we'll go into damages, right? In the area of state responsibility as such, as you have well pointed out, the influence is it's direct. But I find that a beautiful exercise. I mean, I don't have any. I don't think that everything applies. I mean, I don't think that necessarily everything applies. And I'll give a few examples. For instance, in the latter part of the articles on state responsibility, on circumstances precluding wrongfulness, there we can the investment treaty arbitration panels and council have mostly developed the notion of necessity in the Argentine cases, and at some stage there were misunderstandings as to whether necessary measures really implied necessity, and that was clarified by Crawford in a later annulment decision, etc. But that is a specific example. Now, possibly what one can see is some sort of development, mostly in the sanctions and counter measures regime, which hadn't been developed. But that, I mean, to me, that is those are unlawful acts of state that have breached. And when I say to me, those, I'm referring to the violations of international law, not to the circumstances precluding wrongfulness. When a state breaches a bilateral investment treaty, then under the articles, which at least Article 2 would be customary international law. I mean, at least that very article which determines what leads to liability, attribution, and a breach of an international law obligation. So at least that should lead to state responsibility, and then you apply the provisions on attribution and the other provisions. But that is, and I understand that we're not necessarily dealing with a wrongful act done by a state against another state. That being said, there is still the notion of breach of international law, and that's why I don't feel sort of violated when the notion of applying this to investor arbitration is embraced in general terms. And yeah, and by the way, the comments, the initial comments, which now have been updated, were very much, in many respects, thought of having, at least to some extent, in mind, in the original comments, investment arbitration. There are examples of investment treaty arbitration in the original comments drafted by Crawford. Anyway, that's it.
Great. Well, thank you all. It's a testament to Professor Dupuy that even in his absence, he can stimulate such an interesting conversation. But we do have to move on. We're going to turn next to Jose Antonio to discuss substantive obligations under investment treaties.
Okay. So just allow me 1 second. And let me share with you somehow.
I think you have to do it through Zoom. Yeah.
So
Here you go.
So, I mean, here, the task to speak in 7 or 8 minutes about the influence of public international law on substantive obligations is a very difficult one. It would be impossible to just trace each one of the decisions. But what I would like to do or attempt to do is at least give a general overview of how relevant have been some of the instruments or decisions of commissions of international law, and I use the term public international law adjudicatory bodies in a very broad sense. We know which one is the World Court, the ICJ, but beyond that, there has been significant influence of bodies before the ICJ and before even the PCIJ. So, for instance, so what I will have, or what I will refer to is I've selected 3 specific substantive obligations, one most favored nation, the other one with fair and equitable treatment, and the other one expropriation. And we could talk more national treatment and many others, but this is just to give a flavor of how might that relation be. And unlike in the case of the articles on state responsibility, where the influence is very straightforward, is very direct, I think that here we see in some cases a certain standard in the substantive obligations, and then when we see how that has influence investment treaty arbitration, it changes. One principle that I believe that now has been clarified, but was relied upon was or is the jus dem generis principle, which really was when you look to do some historical research, you go back to the Ambatiellos Arbitral Commission's case, and there it was more of wasn't an investment case, it was more of a trade related case, and the question was posed as to what does that mean? What does being of the same kind mean? And in some of the initial cases that address whether or not a state could rely on MFN to import substantive provisions or dispute settlement provisions from other cases. Normally, or not normally, usually, state counsel would come with the argument, well, the principle, the jus in generis principle, prevents you from importing a fair and equitable treatment from a third treaty into the applicable treaty if, say, fair and equitable treatment is not in the treaty. So that was the way it was argued in many cases. And going back into Ambatiellos, one of the notions that it clarifies is that the gender itself in that particular case was more about trade. And the gender, by analogy, one can say, well, the gender may have been about trade. Here we are in the gender of investment. And that's how you can see some of the decisions in investor-state arbitration, including EDF and Bindeer and others, which allow the importation of substantive provisions that may be not included in the applicable treaty, but they may be included in third treaty. So that's one example. If we move forward, so there I would say there is an influence. Now it's not very notable in the MFN because it's generally accepted. That's how you would apply the principle. If we move forward, and we look into fair and equitable treatment, it's almost impossible to think about fair and equitable treatment without making some reference to some of what parties in investment treaty arbitration considered to be at some stage in history the standard, and the famous or infamous case is Neer versus Mexico by a binational commission, U.S. Mexico. The case is almost 100 years old, not yet, but quite near. The case involved a U.S. citizen who was killed by an armed man in the road on Durango, Mexico, and the case involved questions as to whether or not there had been denial of justice, whether or not there had been a significant flaw in the whole Mexican system provision of justice. The tribunal ultimately, and I mean, this is sort of the near standard, and I am pretty sure that many of you know it, but it's here. The tribunal ultimately referred to the standard needing to be one of an outrage or bad faith or willful neglect or duty, or to an insufficiency of governmental action. So far short of international standards that every reasonable and impartial man would readily recognize its insufficiency. Of course, a lot of things have gone under the bridge. A lot of water has gone under the bridge, and that's one of the beauties of customary international law, that it evolves, and slowly, but it does evolve. And the notion that things have evolved to a no so demanding standard have led to decisions that would question whether you really need to request that high level. We can also talk about the LC from the ICJ. The standard is not phrased in the same manner, but it still needs to shock or at least surprises a sense of juridical propriety. The influence of these decisions is palpable, but my take from it is especially with respect to the nature of public international law, which evolves, and that's why one of the decisions that I would be looking for is the Iran-US case and their development concerning fair and equitable treatment, to see how it has evolved and where we stand. Now, the third substantive provision that or discipline that I would like to refer to is expropriation. And on expropriation, there may be, of course, decisions of the ICJ, but I believe that the strongest influence has been provided by the Iran-US tribunal, and there you can actually see in language, in early language of that jurisprudence, if I may, at least two examples. One in indirect expropriation, and the other one concerning the high standard of substantial deprivation. The words are not exactly the same, but for instance, here in starret housing, versus Iran, what the tribunal indicated was ultimately that the act needed not to be one of taking as such or one of change of the actual title, but a sufficient interference was or an interference of such a degree that that the consequences could be similar as to render the rights of the owner useless, could lead also to expropriation. So there's a clear link between that and current standards of investor-state arbitration. And for the last one, in Tippets versus Iran, the language is not necessarily substantive or substantial deprivation, but the ethos of what the tribunal was constructing was very much in line with the notion that that it could not be a simple deprivation. It could not be simply ephemeral, and that you build more into the high standard that has now been concluded in investor arbitration, and you can trace it to those days. The Iran U.S. Claims Tribunal is still ongoing. It still has jurisdiction. So, and there's still developments on this issue. What I would recommend is going to the World Arbitration Update page, and there's a video precisely tracking how the influence of the Iran Claims Tribunal has taken place in two subjects: one, expropriation, and the other one, nationality. And I would love to talk about nationality, but that goes beyond the scope of what Lee as a moderator would allow me to do. So I'll stop there. Thank you.
Thank you, Jose Antonio. We'll open up for comments and reactions.
I want to make one small point that, again, is maybe outside the scope, but U.S. Iran Claims Tribunal, it's not just substantive influence, but also procedural influence in investor-state disputes, in particular with the UNCITRAL rules. So just throw that out, that there's a lot of intermingling.
Oh, yes, absolutely.
Yannick, any views?
Yeah, a lot to be said. Many thanks. I have to choose. Well, I will choose expropriation, indirect expropriation this time, and the influence of customary international law in relation to regulatory measures and the police power doctrine. But actually, the problem is that customary international law is unclear on those aspects, and this is well reflected in arbitral practice when they refer to customary international law in those matters. For instance, if you take Metanex, the tribunal argued that under customary international law, under international law, a measure which aims at the protection of a public interest objective, which is non-discriminatory, which is adopted in accordance with due process, is not an indirect expropriation, whatever the impact on the investor. But if you look at the view of customary international law by the tribunal, for instance, in Philip Morris versus Uruguay, same principle. As a matter of principle, such a regulatory measure is not an indirect expropriation unless it has an impact which is too severe on the investor. So you have two different views of customary international law, which are quite different and which have quite an important practical impact for states and investors. So 2 points in relation to treaty practice here. It's interesting that in treaties recently adopted, those two approaches are taken on board. So for instance, if you take the approach of India, this is the approach of Metanex. Regulatory measures never to be considered as an indirect expropriation. But if you take the approach of the US, of the EU, well, same principle, but an exception to that when the impact is too severe on the investor. So there is, again, a difference. And last point, there are treaties in which states only refer to customary international law in relation to indirect expropriation. I would strongly recommend to treaty drafters not to refer simply to customary international law, but to make clear what their view on the content of customary international law is about expropriation.
Yeah, I mean, very briefly on the the example of India and other countries, that is also in line with the logic of public international law. If and that actually happens quite often, to the extent that states may not be in agreement with certain interpretations, which is, by the way, the beauty of this system. I mean, I know that it evolves very slowly, but that is an example of how certain lines of jurisprudence, which are not shared by states, may be rejected. Say, well, we do not want expropriation through regulatory action or regulatory expropriation, or what happened in the at the end of the 2000s, many treaties rejecting the Maffesini doctrine, saying, oh no, we do not want MFN as a way to import dispute settlement provisions, and that's sort of the beauty. I mean, and it's also a discussion of sources. Oh well, yeah, well, whatever you want to say in the treaty, we're not going to adopt it. So the states have this power of agreeing to treaties and reacting to it. And no, that was it.
Great, thank you, thank you. We're going to move to our last topic of discussion. Josh will address damages in investment arbitration.
Thanks, Lee. It's fitting that damages come at the end, right? Because they come at the end of every case. But I would say that it's on the topic of the influence of public international law and investment arbitration. It's one of the, if not the most important influences, because investors would not bring claims if there was not a principle of reparation. But it is one of the most contentious issues as well. And I think the contentiousness arises from the opposite problem that Jose Antonio just mentioned, which is there are certain principles of international law that are unclear, and they're, then tribunals struggle to understand what they are. I think with respect to reparation, the issue is the opposite. The principle is clear. It's the application of that principle that proves very, very difficult. So I think there's a different relationship between reparation and investment arbitration. Today, I want to focus on three questions briefly. One, what is full reparation? What does it mean? Two, why is it important? And three, how is it implemented in investment arbitration? So first, what is full reparation? International law requires that a state responsible for an unlawful act must make restitution by putting the injured party into the position that it would be in if the wrongful act had not occurred. This is in the draft articles of state responsibility. And in many cases, it's brought through reference to the Chorzów factory case by the Permanent Court of International Justice. Again, a case that's almost 100 years old. Professor Dupuy makes an interesting contribution when he discusses why the Chorzów factory case is sometimes not appreciated or not accurately applied in investment arbitration. But I think some tribunals, and at least one in Teyenver versus Argentina, recognize that the Chorzów case is not the source of customary international law, but it was a statement of it. And so I think the reason that the Chorzów factory quotation is used so often is because it's so accurate and still survives today. So here's the statement. Reparation must, quote, wipe out all the consequences of the illegal act and reestablish the situation which would, in all probability, have existed if the act had not been committed. So again, restitution is the preferred remedy, but in investment arbitration, that's almost always not a possibility. So then the question is, what is the reparation or the compensation that would accomplish restitution? This is frequently referred to as the but-for world. It's a hypothetical context. It's easy to understand the concept, but it's difficult to apply. And this is an area where I think investment arbitration has added clarity to what the principle means. And I'll give one example. So even from the days of the Chorzów factory case, there was a concept of separating lucrum cessans from damnum emergens, so splitting out lost profits. And sort of modern economics and advances in understanding of finance So that doesn't make much sense. So that has been set aside. That's not a principle of customary international law. It's how it had been applied by some tribunals and courts, and we've moved on from that. But that doesn't mean that everything is resolved. So why is full reparation important? There are two fundamental purposes. One is to deter states from unlawful act, from violating their treaty obligations, and the second is to restore those who are harmed to the position they would have been in without the violation. This goes to the heart of the rule of law. If there's not reparation, states would have their obligations would lose their force at the international level. Picking up on Jose Antonio's points about expropriation, I'm going to focus on that because it's the clearest conceptually with respect to applying full reparation, but of course, there are damages issues that arise under different substantive obligations. So there's been often in the investment arbitration cases, there's a debate between a lawful versus an unlawful expropriation. And I think there's an interesting article by Stephen Ratner, which I would recommend, that suggests that phrasing sometimes sounds wrong. That really the issue in investment arbitration is it a treaty compliant expropriation or a treaty violative expropriation? So I think lawful and unlawful is used as a catchphrase. The point here is that there's no doubt that states have the sovereign prerogative to lawfully take property as long as they satisfy their obligations freely entered into at an international level. In that scenario, it's important for states to be able to assess in advance what the compensation they would need to pay, particularly when an investment treaty, as is typically the case, requires payment of compensation. But the situation is different when the state pays no compensation at all. It does not even make an offer of compensation. And that is where tribunals have focused on the concept of an unlawful expropriation. Probably the most famous decision is in the UCOS case. And there the tribunal said, quote, conflating the measure of damages for a lawful taking with the measure of damages for an unlawful taking is on its face an unconvincing option. Why not? Why should compensation be different if it's lawful versus unlawful? The reason goes back to the purpose of full reparation in the first place. If there was no difference between the compensation that flows for acts that comply with treaties as compared to acts that don't comply with the treaties, there would be no incentive for states to comply with those obligations in the first place. How is this principle of full reparation implemented? This is an area where I think there has been an advance in understanding. 10 years ago, I wrote an article toward a more exact science in valuation and investor-state arbitration. And I think the field has moved in that direction in the past decade. I'm going to focus on one example because there are a lot of issues that come up. It's a case-specific question about damages. The example is the data valuation and the role of ex post information or data that arose after the expropriation. Remember that full reparation does not start with compensation. It starts with the concept of restitution. If we had a time machine, this would be easy. The tribunal could go back in time and give the property back. That would be restitution in its clearest conceptual sense. That's not possible. The tribunals struggle with how to accomplish that through a payment of damages. And this is where the split comes in. The position of investors is that states should pay for any increase in value after the expropriation, when it's an unlawful expropriation. The position of states is that the treaty, most investment agreements, required only compensation as of the date of the taking. So you should not get the increase in value. So who's right? I think the debate has been about what's the proper valuation date. Should it be the date of the taking or the date of the award? And there have been a few decisions that have shed important light on this that suggest that a better focus is on whether and how the tribunal should use ex post information. Because if you think conceptually, and this is again a point that Ratner explains well in his article, if you do a valuation on the date of the expropriation, but you use information from later, for example, if it's a gold mine and the price of gold goes up, the tribunal says, we'll do a date of expropriation, but we will use the actual gold prices. That's the same thing as a date of the award valuation. And that distinction is lost sometimes. The question is, how do you and when do you use ex post information? Professor Brigitte Stern, in her dissenting opinion in Kiborax versus Bolivia, highlights that it's often inconsistent in the way that tribunals pick and choose. Which information should they use? Which information should they not use after the expropriation? I think more recently, the tribunal's decision in Conoco versus Venezuela makes an important advance in this respect. It expands on Professor Stern's logic. It finds that the ex ante information, in other words, the information existing at the time of the expropriation, sets the bottom line. And that ex post information can be taken into account. And here's the key point. When, how, which information? The tribunal explained that the focus should be on causation. And I'm quoting, causation including mitigating factors like intervening or concurrent causes, contributory negligence, or proportionality. This is an important principle. Causation and proportionality come from concepts of reparation under international law. You see them in the draft articles of state responsibility. I think that is the right place to focus. And I'll give two very extreme examples. I already mentioned the gold mine. When there's a commodity price at issue, it's very easy to observe that price. The investor and the state knew that the value depended on that price at the time of the taking. So there, causation is probably satisfied. You would take into this, the tribunal should take into account the information. Now, let me give you another extreme example. A state expropriates Zoom, the company Zoom, 1 month before the COVID pandemic starts, right? Does everyone know what happened to the value of Zoom after COVID? It went up a lot. Did anyone expect COVID? Not directly, not really, not the way it happened. So that's like a black swan event. That probably fails the causation test, fails the proportionality test. So I think that is the right way for this debate to proceed. So I think the Conoco decision was important there. There are a lot of other different issues where this comes into play. I've just chosen the ex post information and the valuation date. But the key point, back to our topic, influence of public international law and investment arbitration, is that there are some issues like reparation where the concept or the principle under public international law is clear and conceptually simple, but it's very difficult to apply. And in those circumstances, I think investment arbitration can serve an important role in clarifying what the principle of international law means. So again, to Janek's point at the very beginning, I'm not saying that arbitral practice in any way creates or changes international law, but it is clarifying what that principle of international law means in light of specific facts and particular controversies. So with that, I'll stop.
Great, thank you very much, Josh. Well, we're coming close to the end. So what I propose to do now is we do a speed round on comments. If anyone has them on the panel, 1 minute tops, maybe 30 seconds.
I don't want to start.
He doesn't want to. Okay, that's
Okay.
probably.
Maybe I can start in relation to something you said earlier with regard to the analogy and reparation. I mean, you seem to suggest, if I understood you correctly, that in one way or the other, you have the same conception of by analogy that Professor Dupuy. Your point is that all things being equal, part 2 and 3 apply. That was not really my understanding of Professor Dupuy, is that when he says by analogy, he says, well, this is a source of inspiration, but this requires more than adjustments. This requires, for instance, to take into account the conduct of the investors, to look into general principles of law, to precisely adjust rules which have developed in an interstate context. So I think that this conception of by analogy leads us to move away more from public international than yours, if I understood you correctly, of course.
That's a good point, and it brings up maybe my 1 minute remark, which is that going back to the question of unlawful versus unlawful, treaty compliant versus treaty violative, what is the international obligation that has been breached in investment arbitration? It is a treaty obligation. And so that treaty is between two state parties. And then if you look at the commentary to Article 33 in the draft Articles of State Responsibility, it recognizes that when a state breaches its international obligation against another state, that the benefit or the remedy might accrue to a different person. In investment arbitration, that tends to be the investor. So I think that's how the analogy applies.
Well, it speaks to the triangular nature of investment treaties. We only have two parties that are involved in negotiating and entering into those obligations and what their contents may be, but you actually have a complete outsider who's seeking to reap the benefits of that negotiated agreement.
Great, thank you. Let's leave it there. What I'd like to do is, because we do have another panel coming in a bit, maybe take a few minutes for questions. And we'll start from any questions in the room, and then we'll see if anyone virtually would like to raise a question. Anyone have a question for our panelists?
Thank you very much. Very insightful, very interesting discussion. But I kind of have a feeling we're dancing around this topic of whether actually investor-state arbitration is part of public international or not. Because are we conflating public international law and standing that the investors have to bring a case against a state? So we are talking about public international law obligations, right? So it is part of public international law. And we have investor who has a standing to bring a claim against the state. So maybe that somehow resolves all these issues that we've discussed in terms of the articles on state responsibility, the Professor DP comments as well. What are your thoughts on that?
I mean, if I may, I don't have any conflicts with. I mean, I strongly think that investment treaty arbitration is part of public international law, and I think that the basis and the similarities are very clear, unlike in other areas of specialized international economic law, such as WTO law. I mean, I also think that WTO law is part of public international law, but there you have a more specialized system of international law. Here, the influence is way more clear. That being said, the investment treaty arbitration, investment international law has certain peculiarities. You have mentioned one. There is international right of recourse of investors, because the system was created that way, to go and knock at the door of international tribunals. That doesn't happen at the WTO. That doesn't happen at the ICJ. That it doesn't happen in other areas of the law.
Human rights you do.
Well, human rights you do, but before tribunals, I mean, you can go before the commissions at the UN, etc., the reports, but it's not technically speaking adjudication. So I think that there are areas of specialization here, and there are things that characterize investment international law. But I absolutely think that it is part of public international law, and the question might become an issue when you do the exercise of looking into potential tribunal members, because there you go like, oh, but this tribunal member may have a more commercial background, commercial arbitration background, etc. And then it becomes an issue, because what if your arbitrator doesn't think that it's part of public international law? Yeah, you might be in trouble.
So it's a pretty provocative question. Maybe let me answer it with a provocative answer, which is not my own. But in one of the chapters of our book, Professor Freddie Surgeons of Washington University argues, and I'm paraphrasing here, he argues that investment treaties are not treaties at all, but actually they're just contracts where public international law is only applied by analogy. So, it's not my argument. I encourage you to read more about it, but maybe it's all applicable by analogy.
I'd be curious to hear what the states think about that.
Yeah, the last one to be asked usually.
But treaty is a contract between states, right? It is a contract with public international contract.
You just answered your own question.
Great. Any other reactions, or maybe take another question, please?
Yeah, speaking about the evolution of public customary law, there is a debate. There is a current debate at the UNODC level concerning the effects of corruption and how do you measure the damages of corruption. I think there was it was a debate on September tackling the private remedies to corruption. And they are quoting a case in which the cost, you can of course adjust the cost if a corruption action took place. But I'm interested in how do you take into account other remedies which we find in transnational law, in public international legal law, like the global regime against corruption, the global regime against money laundering, which compels you to measure the damages of corruption by taking into account all forms of reparation, like they are using this term asset recovery through arbitration, but through asset recovery we understand confiscation, we understand reparation, compensation, everything that's available to a victim, because it is indeed a triangular relationship, but then again the victim of a corruption may be the society, so each citizen may be able to claim victims for corruption. So I'm interested in how do you reflect upon this spectacular development of public international law, including interplaying two different regimes.
I think that would be a great topic for an entire panel, because corruption is an important issue. It has not been addressed as a matter of remedy in investment arbitration. It's usually one of jurisdiction and or admissibility. But there, tribunals certainly are trying to understand, even outside of the domestic national law prohibitions of corruption, how do general principles of law and how do they apply in those circumstances? But I think that's it's an important and developing question that should be on a panel next year.
And
Are you taking notes, Jose Antonio?
absolutely, we're all taking notes. There's one award which is called Metal Tech, and in that particular award there was, as Josh explained, the issue was solved at I believe at the jurisdictional level, because the investment was predicated to be tainted by corruption. So that being said, I believe, if my memory doesn't do me wrong, I believe that at the cost level, the tribunal found a way where some of the award on cost would not necessarily go to one of the parties, because the issue was, well, there was corruption, but corruption normally takes a dance by two, right? So the part on the cost allocation, I believe that was somehow related to a special fund of the UN on corruption. I'm not entirely sure, I may be wrong, but you may want to look at that decision.
Thank you so much.
Yeah, I mean, in relation to jurisdiction, I mean, this is not needed to look outside international investment, in the sense that in many treaties, as part of the definition of an investment, you have the compliance with domestic law at the time the investment is made. So in case there is corruption, this criteria is not fulfilled, so the tribunal has no jurisdiction ratione materia. And even when you have a treaty which does not contain this requirement, some tribunals have been ready to consider that this is inherent to the definition of an investment and consider that the claim was inadmissible. So within the investment law regime, we have already tools to deal with that, at least at the jurisdictional stage.
Great, thank you. I think we can take one more question from the room if there is one, and then we've got one virtual. Anyone else have questions? No? Okay, we'll go to our last question is from Eric Brower. Thank you very much for a very interesting panel. One question, how far do you think an arbitral tribunal can rely on Article 31.3c of the VCLT based on Iuria Novit Curia, i.e. even if the parties make no reference to it, without running the risk of acting ultra extra petita? A lot of Latin. But it's an interesting question. To what extent can tribunals draw on public international law, even if the parties haven't raised it?
Well, I must say that I will discuss this with him when I'm back at the university as my PhD student. So, thank you, Eric, for asking that question. But I mean, just very shortly, I mean, with Huron Court, then what matters is that the tribunal leaves the opportunity to the parties to express their views on what the tribunal brings on the table. So as long as this due process requirement is met, there is no issue in my view.